Welcome to Law Sessions. I am Jennifer Housen. In this session, we will consider co-ownership in this second lecture of co-ownership. In a previous lecture, we considered severance, but the entirety of this lecture will consider trust, and in particular, we will focus on the majority of the cases which in recent times have looked at the matrimonial home. Now, land law exams generally have two questions in relation to co-ownership. One relating to severance, which is already discussed in another lecture, and the other will usually look at trust in relation to the matrimonial or family home. Wherever there is not one person of full age and capacity entitled to the whole estate in law and equity, then you will see that there may very well be a trust. So, for example, co-ownership of a legal estate is generally straightforward. There will necessarily, of course, be co-ownership of the legal estate where and only where the legal estate is vested formally, inter vivos, meaning whilst you're alive, or on death in two or more persons. In the case of a registered title, the vesting will have to be completed by registration of the co-owners as the new proprietors. There cannot be more than 4 co-owners of the legal estate, and they will, of course, usually be joint tenants at law rather than tenants in common. A legal joint tenant cannot be severed. That is, it cannot be converted into a legal tenancy in common, as there is no such thing. Of course, the lecture on severance has dealt with this in detail. For co-ownership, there must be at least one other person in the landowning relationship. So, if there are 2 legal owners and 1 beneficial owner, if there's 1 legal owner and 2 beneficial owners, or 2 legal owners and 2 beneficial owners, this will amount to a co-ownership situation. If you're only looking at a situation where one person legally owns and is solely beneficially entitled to the property,